We're going to come back to session now. I believe, Brian, you're up.
Commissioners, I have used my time efficiently, and I'm going to apologize. My questions may jump around a little bit, but that's because I have blocked off about 2/3 of what I intended to ask the assessors. As my first witness, I would like to call Rhonda Ferris. Ms. Ferris, you've been previously sworn in. Can you please identify yourself for the record?
Rhonda Ferris, I'm the Chief Deputy at Beauregard Parish.
And in your capacity as a chief deputy, you've been responsible for assessing the wells owned by Perdido Energy since they began reporting in 2018, have you not?
Correct.
Okay, I'm just going to kind of go over it real quick because I think it's well established in the record. The only information you received in 2018 in support of the taxpayer's obsolescence request was a copy of the purchase and sale agreement and the Calvanico appraisal, also referred to as the Loop Capital appraisal. And I think just the quickest way to do this, oh, thank you, is to reference the Court of Appeals opinion where they discussed your testimony. And it stated, and I quote, Ms. Ferris testified that she applied LTC tables, which took into account both depreciation and well depth. Perdido then sought additional obsolescence based upon the depth of the wells. Ms. Ferris testified that this request was considered but ultimately rejected because the information provided by Perdido did not support the request and because she was unable to determine how Perdido came up with the amount of obsolescence it requested. Ms. Ferris acknowledged that she was contacted by someone in Mr. Frederickson's organization regarding the request for additional obsolescence. She testified that she replied by email requesting any additional information that the assessor's office could consider to help with obtaining a value for Perdido, but nothing further was provided. Well, first, is that an accurate summary of your testimony from 2018?
Yes, it is.
Okay, and since we now know that the same information was provided to you in 2019, 2020, 2021, I assume the concerns you expressed apply equally to those tax years, does it not?
Yes.
Okay, it referenced that in 2018, they referred to it as Mr. Frederickson's organization, Merit, requested additional obsolescence, sent you an email that you responded requesting any additional information that the assessor's office, that you would accept any additional information they would provide, and that you heard nothing from them. What about in 2019, 2020, and 2021? Did you have any follow-up conversations with Merit Advisors?
In 2019, I don't recall speaking to anyone. In 2020, on June 25th, 2020, a request by email was received from Keelan Lewis with Merit Advisors requesting obsolescence. On 7/8/2020, we advised him by email any information he felt would be helpful in supporting his request for obsolescence would be considered. And on August 31st, 2020, Mr. Lewis stated Perdido provided all information possible, including the appraisal.
So while there were discussions in 20, Mr. Lewis responded by advising that Perdido had already provided everything, including the appraisal, and did not submit any additional information?
Correct.
Okay, what about the following year, 21?
In 2021, on August the 25th, 2021, Perdido asked if there was any other information they could provide on top of the rendition and purchase sale agreement that is on file for Perdido in order to get the extra obsolescence that has been requested. Any information you see fit that could get us closer to our rendered value. And
did they submit any additional information to you in 21?
no, they did not.
Wait,
I'm sorry. On August 31st, 2021, Perdido sent a reserve report.
and what can you tell me about that reserve report?
The reserve report projected revenues through 2035 based on a hypothetical $54.71 a barrel of oil.
Okay, Ms. Ferris, does your office use projections when you assess property or calculate obsolescence?
No, we do not.
You only use actual verified information, is that correct?
Correct.
And did you receive any of the documentation upon which the calculations in the reserve report were based? I asked that, let me ask, that was a terrible question. Did you receive any documentation showing you how the reserve report was compiled or calculated?
No,
Okay. So your office rejected Perdito's obsolescence request in 2019, 20, and 21, did you not?
in 21, we gave a 20% obsolescence on hurricane damaged equipment. And if I'm not mistaken, the 40% obsolescence was also for the wells associated with that equipment
But
due
again,
to the hurricane.
that was solely based upon hurricane damage, had nothing to do with the appraisal or the purchase or sale agreement that was
No.
provided to you.
No,
There was some talk earlier, it was in Mr. Holden's testimony about the fact that taxes exceeded profits and gross revenues from the fields. Were you ever provided any documentation showing that?
no,
There was some discussion about an exhibit, taxpayer common exhibit 14. I want you to look at that document. Have you ever seen that document before?
no,
Was that document ever provided to your office?
no.
So I want to close with the same question I asked you in 2018. In the 2018 hearing, you testified that your office denied Perdito's request for a reduction for obsolescence because you did not believe that Perdito submitted sufficient evidence to substantiate its obsolescence claim. Since Perdito submitted the exact same information in 19, 20, and 21, I assume you also believe that Perdito did not submit sufficient information to substantiate its obsolescence request in those years. Is that correct?
Yes,
I have no further questions. Answer any questions the commissioners might have or opposing counsel.
Good afternoon, Ms. Ferris. So it's fair to say that your office used the tables in the tax commission regulations to arrive at the assessments?
yes,
Was there any analysis of value outside of the use of the tables?
the appraisal that was given, we reviewed that.
Yeah, you reviewed your
Yes.
appraisal. Did you ask any questions about the appraisal of Perdito or its consultants?
No, we did not.
Did you seek any clarifications or any additional information based upon the appraisal as submitted?
No, we did not.
How did you consider the recent sale, the one in 2017, based upon the regulations and the tax commission's regulations? How did you consider that?
How do we consider the price of the sale or?
So
What's your
the
question?
regulation says that a recent sale, arm's length sale should be considered as a measure of fair market value. How did your office perform that task?
We reviewed what they had given us, which was the appraisal, which was an opinion of value, and we didn't agree with the opinion.
Did you review the PSA as well?
Yes, we did.
Okay. And why did you not grant additional obsolescence based upon the PSA and the sale?
Because we didn't agree with it.
You didn't agree with the sale price?
We didn't agree with the appraisal that was submitted.
What about the PSA that evidenced the sale price as adjusted?
It was an unsigned PSA, so we really didn't.
So, okay, so you didn't consider the PSA because Perdito didn't sign it?
We looked at it, but we didn't agree with it,
Okay, you didn't agree with what?
the PSA.
What in it did you not agree with?
We didn't agree with the sales price.
Okay. If what Perdito submitted was not sufficient, what could Perdito have submitted that would have been sufficient to analyze the recent sale that had been performed?
I don't know what kind of documents your company or their company has, so it would be up to them.
It would be up to them. So there's nothing that you would request to help you understand the efficacy of that sale?
We requested any documentation and we would consider it.
I'm just trying to understand what other than the PSA they could have provided to satisfy you.
I don't know any other information y'all have.
Okay. I know Mr. Eddington just showed you some financial documents and an exhibit and that he had just shown that was in our exhibits. Are you aware that the Louisiana Supreme Court ruled that the tax commission is allowed to have a full evidentiary hearing, including information that may not have been provided to an assessor in assessing correctness? Are you
No.
aware of the D90 decision where the Supreme Court made that pronouncement?
No.
Thank you, Ms. Ferris.
Any else?
Yeah, quick question. Hold on. Got too much paper going on here. Here it is. Ms. Ferris, yeah, he kept asking you about what information you needed to calculate obsolescence based upon the purchase and sale agreement. I have a question. I kept referring to it earlier, and I'm sorry this is redundant, but I feel I need to. In the 2018 ruling, the Court of Appeal held that the purchase and sale agreement reflected a sale of a going concern and not a simple asset purchase agreement, and went on to state, and I quote, "As such, the sale price alone without more information and further explanation was not indicative of the fair market value of the property." Did Perdido or did Merit provide you with more information or further explanation about the sale?
No.
Thank you. No further questions.
Thank you.
Mr. Chair, may I ask a question? Ms.
Yes,
Farris,
sorry.
just to go back to the comment on the sale agreement. So is it your office's position that the sale agreement, because it was not signed, was not sufficient evidential matter?
No. No, we reviewed the sale agreement, but it was not signed. So therefore, I mean, it was questionable.
So because it was not signed, you did not regard that in the assessment?
And we regarded it. It was just questionable.
Any further questions from the commissioners?
Thank you.
Okay, so my next witness I'd like to call Rapides Parish Assessor Rick Ducote. Oh. Mr. Ducote, could you please identify yourself for the record?
Richard Ducote Jr., Assessor, Rapides Parish,
And how long have you been assessor?
13 years.
Okay, you've been involved in the assessment of Perdido's wells since they first started reporting in 2018, correct?
Yes,
Okay, now Rapides is a little different than the other parishes because while they just have wells, you also assess some pipelines that belong to Perdido, do you not?
that's correct.
Okay, and in the 2018 appeal hearing, you testified that you had granted an obsolescence reduction on the pipelines based upon utilization using some throughput tables that used to be in the tax commission's table. They're not now, but that's how you calculated obsolescence in 18.
That's
Correct.
correct.
And you continued to use that same formula in, again, on the pipelines in 2019, 2020, and 2021, did you not?
That's correct.
Okay, the record's pretty clear. I think it's been established that for 2019, 20, and 21, Perdido requested obsolescence based upon what they refer to as a backed-in number on the appraisal, and that they submitted the same information and the same request to your office in 2018, 2019, and 2020. Is that correct?
That's correct.
So what they submitted was the same information, and what they made was the same request that the Court of Appeals reviewed and found to be insufficient to prove an entitlement to a fair market value reduction for obsolescence, is it not?
That's correct.
There was some discussion earlier, specifically Mr. Holden's testimony about the fact that that taxes exceed gross revenues and profits on these wells. Was that issue ever raised with you? Were you ever presented any information on that?
Not that I can remember now.
There was also some discussion. Mr. Holden said he was unsure whether it was ever given to you, in Exhibit 14, which is a fairly lengthy summary net lease operating statement. Could you take a look at that document and tell me whether you've ever received it?
Yeah, I don't ever remember receiving or seeing it.
Okay. Well, then I'm going to close with the same question I asked you in 2018, and that is, do you consider the information that Perdido submitted to your office in support of his obsolescence request in 2019, 20, and 21 sufficient to warrant a reduction in value for obsolescence on the wells?
No, I do not.
Thank you. Answer any questions the commissioners may have or Mr. Palazzolo.
Mr. Ducote, did your office grant any additional obsolescence to Perdido based upon the recent sale in 2017?
No, sir.
Why did that not occur, given the regulations involved?
We didn't feel that there was any proof that economic obsolescence existed.
Okay. If your office did not feel like you had sufficient proof, what could Perdido have provided to give you what you need to consider the sale as a proper measure of value?
I'm not sure what documents that Perdido has to present to me. I would assume that if they asked, they would have provided everything that I would need to prove their case.
Was there something in particular that you think would have been good for you to have?
No.
In a March 29, 2020 letter to your office, which is in our exhibits, Exhibit 3, Merit Advisors writes that, as was stated in the appeal hearing before the Tax Commission in October, the property value and resulting taxes due have consumed much of the gross income of these wells since the acquisition. In the current market, if the values are assessed at similar levels to prior years, the property taxes due will exceed 100% of the gross income of the assets, and the resulting impact will be economic destruction of these assets. Would a statement like that by a taxpayer to an assessor give the assessor some pause? Maybe there would need to be some discussions about value?
I would think that there would need to be some proof of why that's happening. And would that rise to economic obsolescence? I don't know.
I have no further questions.
Brian,
Okay, well, I've got to ask the same question I asked Ms. Ferris. Assessor Ducote, in the 2018 ruling, the Court of Appeal held that the purchase and sale agreement reflected a sale of a going concern and not a simple asset purchase agreement. As such, the sales price alone, without more information and further explanation, was not indicative of the fair market value of the property. Did you receive more information or further explanation about the sales price in 2019, 20, or 21?
We did not.
Thank you. No further questions.
I have a question, and I'm just hypothetical. If you don't want to answer it, you don't have to. If the lawsuit would have turned out differently, it would have ruled in the favor of the company, would the assessor went back and revisited the values for those years?
Mr. Chairman, I still think that, in my view, they never proved that there was economic obsolescence other than a difference in price.
Thank you. I was just curious.
Mr. Chair,
Go ahead, Greg.
in one side, I think I hear that the First Circuit said it's a going concern sale. You can't go by the purchase agreement. Then I hear more so from Ms. Farris that they couldn't substantiate that the value in the PSA was appropriate. So we used tables and went along that way, and then there was an appeal because of obsolescence. So that seems to be more the focus, but it keeps coming back to a going concern sale as opposed to an asset sale. Let me get my next thought if I can. So is the consistent side from the assessor, and I, Mr. Edrington, I would ask maybe to address that in your questioning, is the consistency the fact that the assessors never felt that there was substantial information provided by the taxpayer to argue the obsolescence, not arguing a going concern sale? It seems that that point just throws the PSA out the window. So I'd ask both sides, if appropriate, to help me understand that.
Sure. Well, I'll ask Mr. Dakota if I understood your question. If not, or would you like to ask it directly?
I guess what I'm trying to put together is an overarching theme here, in that the subject matter of a going concern sale keeps coming up.
Mhm.
What I'm interpreting from the assessor's side is that we're just totally ignoring the purchase agreement. We're
Well,
going off taxed upon depth and assessing accordingly. The taxpayer is asking for obsolescence. The assessor is saying, I don't have enough information to understand what you're asking for obsolescence, and the same information was provided for all 3 tax years. So it comes down to the matter of obsolescence, not the going concern in the purchase agreement, if there's going to be consistency with all the assessors on that matter.
I believe there will be, and I think it was one of those questions I cut out in my trying to streamline.
And Mr. Romig, are you also asking that of our side? Because if so,
Yes,
I'd
I
like-
am.
I would like Mr. Holden to be able to come back up just to answer your question.
He's already
Which we-
rested.
Well, you know what, Mr. Eddington, this is a fact-finding commission, and if the commissioners have questions, they ought to be able to get their answers, and the witness is right here on our side, and it would take no time to be able to do that.
It's up to the commissioner if he wants to ask Mr. Holden the question or not.
Yes, I would like for both sides to address this issue. If Mr. Holden is the appropriate person to address it, then I would like to hear both sides.
Brown, if you want to object on the stand.
Yeah, I'll just enter objection for the record. Yeah, you can call Mr. Holden up. And in the meantime, I'll try and find the questions I had on that point. Redirect. Let me see.
Mr. Commissioner, I think
Here.
it's a really good question. If I was to put myself in the shoes of trying to validate that statement, I think going concern, is a two-pronged test or two-pronged approach. To my knowledge in the M&A environment, going concern could implicate one of two things. On the one hand, it would implicate the sale of a going concern in terms of a business, a viable business. On the other hand, a going concern can be referenced to an entity that does not have sufficient liquidity or capital resources to be considered a going concern. And you'll see accountants refer to a going concern opinion in the financial notes of an audit that says, we're worried about the financial viability of this business. In this particular case, I have to assume that the going concern referenced in the tax commission's decision was that they viewed the transaction as the sale of a business unit or business division. I'm shocked by that conclusion because I'm not aware of any evidence that was supported in the 2018 hearing that substantiated that in any way. When you look at the facts of the transaction, the purchase and sale agreement that was used is a purchase and sale agreement. A purchase and sale agreement is used for the conveyance of hard physical assets. The conveyance of a going concern would be handled through what is called a membership interest purchase and sale agreement, referred to colloquially as a MIPSA. That would be the conveyance of stock in an entity. So, the purchase and sale agreement, because it is a PSA, in my mind, clearly establishes that it was the conveyance of assets. Further, because there was no back of office, there was no geotechnical, there was no, conveyance of people, I really struggle to understand, how the previous commission, viewed this transaction as a sale of a going concern.
Okay, and I appreciate all of that information. I'm sure I wasn't clear in my request. I'm trying to get to a starting point where there was a PSA provided to the assessors. The assessors, second time I think I'm hearing that the assessors are saying the PSA was not a document with which to establish a base for taxation.
Right.
So whether it was a going concern or not, that was the first piece of evidence provided to the assessors together with the appraisal for these years. Then seems the next step is assessors, I'm not going to say disregarded, but did not establish the taxable element based upon the PSA. They utilized tax tables. Then the challenge was not so much the PSA, hey, we keep providing the PSA as evidential matter, but we're having obsolescence, and that's really where the sticking point seems to come in. Is that, so it's not whether or not it was an asset purchase that couldn't be substantiated. It was whether the PSA wasn't signed, so we didn't take that as a valid document. Although Indigo did sign it based upon the copy that we have, and I don't know law, so if that, I'm not going to say trumps, but if it supersedes the purchaser signing it as an authorized document, I guess that's where I'm trying to start putting these pieces as we begin to wrap up the afternoon is what is the issue here? And if the issue is obsolescence more than anything that could not be provided or was not provided based upon the consistency of the information to the satisfaction of the assessors, and that merit in their efforts to try to understand what more could be provided, nothing more was provided. So maybe it's a statement and not a question, but I'm just trying to understand where we are in this as to what's being asked of the assessors in their position.
Assessor, no, Commissioner, I understand your question and you're right. The problem, well, first, I need to clear something up since they opened this door. Mr. Holding, you just testified a moment ago that you were shocked at the tax commission's conclusion that this was a sale of going concern, correct?
That's correct.
Excuse me for beating that dead horse. Did you appeal that ruling to court?
Yes, sir.
How far?
To the Supreme Court.
And,
The Supreme Court didn't hear our case.
okay, well then, let's back up a step. What about the Court of Appeal? They heard your case. What did they hold?
I believe that was a decision that was 1-1-1.
Well, no, it wasn't 1-1-1. There's no such thing. But the Court of Appeal specifically held that it was a sale of a going concern and went on to hold that without more information or additional explanation, which you didn't provide, it was not a valid indicator of value. Did they not? If you know.
Yeah, I'm not familiar with the specifics.
Okay. Thank you. Back to your question. Yes, the issue is obsolescence. The issue has always been obsolescence. The taxpayer provided returns 18, 19, 20, and 21, in which they requested varying amounts of obsolescence. The law is very, very clear, and they're represented in the decision that it is the party seeking a fair market value reduction for its property based on obsolescence who has the burden of producing sufficient data and information to substantiate its claim. The Court of Appeal also wants to say that the
Mr. Eddington, are you
assessor
testifying?
retains the discretion to determine whether the taxpayer has substantiated the obsolescence. Now, that ruling came out. They keep talking about D90 as it was some great revelation. That ruling came out after D90. D90 was the whole basis of their appeal to the Court of Appeal and the request for review by the Supreme Court. The issue is very simple. The issue presented by this appeal is, did the taxpayer submit sufficient evidence that the assessor's rejection of their request for obsolescence rose to the level of an abuse of discretion. Again, I think the most telling thing you've heard today was Mr. Frederickson's candid admission, well, we were in litigation, so we kept doing the same thing. I think it was the chairman asked a question, let's assume the decision had gone the other way. I can't testify hypothetically whether the assessors would have done something, but guess what? We would not have a case here today. Flip side's true here. They're married, for better or worse, to what they gave to the assessors prior to the close of the deadline for filing a protest with the Board of Review. And all they gave, it was a strategic decision they made, was while that litigation was going on, we're going to ride this horse.
Mr. Chairman, Mr. Eddington is giving argument, and if he's going to be able to do that, I
We'll
would
do it,
like.
I apologize.
permission
We'll
to
do
be
that
able to
when
do
we
that.
close. Let's get back to
Okay.
any more questions for this witness.
So, Mr. Assessor, when the sale document was provided to your office, that wasn't taken into consideration.
We considered it. I looked at it, reviewed it, but we had no information that showed that there was economic obsolescence anywhere.
But this was at the establishment of the taxable base.
Right, I understand, but comparing that to the guidelines, there's such a wide discrepancy in this sale price and what the guidelines say. They're saying there's economic obsolescence that's causing that, but no proof that there is.
And the guidelines being the tax tables with the depth of each well.
Yes, sir.
Mr. Chairman, may I ask a question in this regard? I think that's where we were in the process. Yeah, Mr. Dakota.
Okay.
Yeah, I mean,
Brian,
So-
you finish your,
Well, no, actually, I had one more question.
Go
before we
ahead,
move on
Mr.
to
Eddington.
that.
Go ahead.
Greg, I'm sorry. Did they answer your question to you?
No, no, no. And
I'm good,
I
thank
think
you.
we're really kind of getting down to ground zero.
Okay.
Assessor Dakota, now, prior to the change in Chapter 9, you're valuing oil and gas wells on the income approach now. But prior to that, how are you required to determine the tax basis, the value basis of an oil and gas well?
By using the tables.
I mean, that was the tax basis according to the law for ad valorem taxation purposes.
That's correct, yes.
And when tables, just to clarify, you mean the LTC approved tables in Chapter
Yes.
9?
Yes, sir.
Thank you.
and Mr.
Okay,
Dakota,
now
we
answer
we
the
don't
questions.
dispute that it was proper for you to use those tables. I think that the question that we're struggling with is, in that same rule, there's provisions on obsolescence. And one of those provisions on obsolescence is consideration of a recent arm's length sale being a proper measure of value. And that's what we're trying to find out. What more could the company have provided that it didn't provide? Is there, especially given, the caution in 2 different tax years where they're saying, look, the taxes are so high, it's going to basically destroy these assets. What more could they have provided to you?
I don't have that answer. I don't know what documents that company may or may not have to give to us, but when we see the sale of whatever it was, $4 million, but then that's for all of the assets or the company or whatever it was, compared to what the tables are saying us to value these assets at, there's such a wide discrepancy of that. We're going to use the tables unless there is some reason not to. And for the company to say, oh, it's because of economic obsolescence, but to show none other than the difference in sale price and what the tables are, doesn't rise to me to have enough to say, hey, okay, I see it exists. I'm going to use that. That's just speaking for Rapides Parish.
Right. And I believe that's why that company submitted the PSA to you, also submitted an appraisal to you. In addition to that, the LAT 12s, which is really quite a lot of information to be submitted by the early deadline. I think they were struggling just to find out what they could have done to show some reason between this disparity, Okay. Yeah, I think.
Mr.
we
Chair,
got-
one more question. So fair market value, functional and/or economic obsolescence shall be considered in the analysis of fair market value. I'm just going to put period. We know it goes on as substantiated by the taxpayer in writing, but just stopping there. So you have the PSA, you say, I've got all of these wells, they had this depth, the table says this, and the taxpayer's here. That's quite a gap. So what is the consideration for obsolescence beyond just saying, it doesn't make sense, I'm going to go with the table?
Well, I guess outside forces that affect the value of those assets, were there any? I don't know. They never showed me that there was. I believe it's simple as that.
So the consideration is it could be there, but they didn't provide anything.
Yes, sir.
Any further questions? Okay, thank you, Mr. Cody. I'd like to call Michael Beeler. Mr. Beeler, could you please identify yourself for the record?
My name is Michael Beeler, Vernon Parish Assessor.
And how long have you been assessor?
I was elected in 2015.
Okay, so you've been assessor for the full time that your office has been assessing the wells owned by Perdido Energy, have you not?
Yes.
Okay, just to try and kind of streamline this, in the 2018 hearing, you testified that you reviewed the information submitted by Perdido and rejected the obsolescence request because you did not believe the request to be adequately supported and documented. Do you recall giving that testimony?
I do.
Look, I want to just read, because it's very, very brief, your testimony. This is quoted from the First Circuit Court of Appeals ruling. Michael C. Beeler, Vernon Parish Assessor, testified that he reviewed the tax reporting form submitted by Perdido, as well as its request for additional reductions based on obsolescence, but he denied the request because it was not adequately supported or documented. For instance, Mr. Beeler explained that Perdido requested an additional reduction for functional obsolescence beyond the obsolescence provided for in the LTC tables based on well depth, but did not explain how it alleges the well depth functionally impairs the well, or what the percentage reductions requested represent. Given the fact that what you received in 19, 20, and 21 was the exact same information that you received in 18, is your answer the same today?
Yeah.
And again, I know you testified that all you received, and it's pretty clear in the record, was the Calvanico appraisal and the purchase and sale agreement, but there's been some discussion about the fact that the taxes exceeded the gross revenues and the profits on these wells. Did you ever receive any documentation, evidence, anything other than a statement and a letter to support that statement?
No, I did not.
Okay, there was also some discussion of a taxpayer exhibit 14. It's common exhibit 14, which are some spreadsheets. Mr. Holder said that he knew it was submitted to the tax commission, but he knew if it was submitted to you. Can you tell me, have you ever received that document?
No, sir, I've not seen it until today.
So the information that you received in 2019, 20, and 21 was the same information that the Court of Appeal reviewed and found to be insufficient to prove an entitlement to a fair market value reduction for obsolescence in 2018, correct?
Yes.
So I want to close and ask you the same question that I asked you in 2018. Do you consider the information that Perdido submitted in support of its obsolescence request in 2019, 2020, and 2021 sufficient to warrant a reduction in value for obsolescence?
No, I did not.
And since I'm just going to save myself having to call you back in a second. In the 2018 appeal, the Court of Appeal held that the purchase and sale agreement reflected the sale of a going concern and not a simple asset purchase agreement. As such, the sale price alone without more information and further explanation was not indicative of the fair market value of the property. In 2019, 20, and 21, did Perdido provide you with more information or further explanation of the sale?
No.
Thank you. No further questions. Please answer any questions the commission or opposing counsel may have.
Opposing counsel first.
Mr. Beeler, how did your office consider the recent sale based upon the regulations in the books?
Well, we reviewed it along with the other information that was submitted by the taxpayer, and we did not feel that it was an accurate representation of the value of the property.
Was there anything that Perdido could have provided to you that would have given you more clarification?
I'm not sure.
No other questions.
Any questions by the commission?
Thank you, Mr. Beeler. And last but not least, I'd like to call Chris Guillory. Good afternoon, Mr. Guillory. Can you please identify yourself for the record?
I am Chris Gilroy, assessor of Evangeline Parish
And,
since 21.
okay, that was gonna be my next question. So you've only been the assessor since 21, and you were not involved in any of the actual assessments that are being challenged today, but in preparation of this hearing, in your capacity as assessor, did you go back and review everything that Perdido filed with your office since it began filing returns in 2018?
Yes,
And again, it's, since you weren't there for any of these years, I'm just gonna ask the question that I think is already clear in the record. What was filed in 19, 20, and 21 was the exact same as was filed in 2018, correct?
yes,
Nothing different?
no, sir.
There was some testimony earlier about, a claim that the taxes on this property exceeds the gross revenues or the profits. Did your office ever receive any information?
No,
showing
sir.
That?
Again, I asked my chief deputy who was in the office in those years.
Okay,
And
and,
he has confirmed that he has not seen those documents.
and what about Exhibit 14 we talked about earlier with the other assessors? It's a spreadsheet that Mr. Holder referenced. Look at the document, does that appear anywheres in your records?
No, sir.
Okay. And since you weren't there for the years, I guess that's really all I have. Well, let me just ask you this. In your capacity as assessor, do you consider the information that Perdido submitted, the Calvanico appraisal and the purchase and sale agreement sufficient evidence of a loss to value, a reduction in value for obsolescence?
No, we used the tables that the tax commission had provided, and that's the other 100 wells in the parish were valued the same way.
Thank you. I have no further questions. Please answer any questions the commissioners or opposing counsel may have.
Opposing counsel.
Yes, sir, how did you consider the recent sale based on the regulation?
The sale,
Yes, sir.
we didn't, they looked at it. Asking my chief deputy, he said he looked at it, but he went with the same guidelines that the tax commission provides for oil and gas wells.
So how did your office evaluate the requirement that obsolescence based on a recent sale should be considered? How did your office comply with the regulation in the obsolescence section that a recent sale should be considered?
I'm assuming they comply, that they used it the same way that they always do, with the sale, but oil and gas, their statement was they don't use the sale as they use the tax commission guidelines to value all oil and gas wells.
Thank you.
I'd like to share this information also with y'all, that looking back, and I had my staff run these numbers in 16 and 17, those wells were assessed the same way by tax commission guidelines prior to Perdido purchasing from Indigo. They actually, Indigo was paying 30% more in property taxes prior to the acquisition by Perdido. So Perdido, they inherited a property that was already paying that off of tax commission guidelines. Guidelines have changed, and today my staff, we value according to the new guidelines. Okay?
Thank you. Questions by the commission?
Yes, sir. So if you don't, you don't have to speak individually for your office, I guess more for you on behalf of all the assessors.
Sorry.
So just as a point of clarification, I keep coming back to this sale agreement. So law basically provides that the assessors are allowed to utilize the tax tables for these, and the sale can be disregarded. Is that what I believe you had said, that sale was disregarded, whether it was an asset sale or a going concern sale?
Yeah, please understand, he was an assessor at the
No,
I
time.
understand, that's why I'm
according-
asking you.
Okay.
According to my chief deputy,
Okay.
I asked him what was policy, how do they handle, I mean, we don't have a lot of oil and gas wells, but we have a little over 100. And he said, Chris, this is what we do. We look at everything, but at the end of the day, to be uniform, we use the guidelines that are provided by the Louisiana Tax Commission to come up with a value. That way, everybody, I mean, if one comes in and complains about this other one's assessment, hey, we use guidelines. No different than putting on a house at $150 a square foot and then putting it for $40 a square foot for someone else. That's just,
Okay, so the determination of an asset sale or going concern sale, once again, the assessors are not looking to that by looking at the agreement and making the determination if it's a going concern or an asset sale. If it were an asset sale, it still wouldn't matter. They would start with the tables.
No, that's fact incorrect. First off, the assessor is not allowed. The assessors, prior to the change in the law, were required to value oil wells based upon the tables. There is an additional provision that says that obsolescence properly documented shall be considered. That's what we discussed. That was the 18 hearing before they kind of, they lost and they shifted their strategy. Now, understand, the issue is not that the assessors disregarded the sale. I mean, this was heavily litigated all the way to the Supreme Court. There are copies of the briefs to the Supreme Court, and they were arguing then just what they're arguing now, that, you know, D90 mandates, and all the courts said no. And the problem was because it is not a simple asset purchase. If it were a simple asset purchase, yeah, no, the rules actually do require that be considered in the valuation of an oil well. I don't know that it's still there, not under the income approach, but it clearly was. So it's not that they disregarded it. It's just this all came on their desk as a request for a reduction in value for obsolescence. Ironically, now remember, they weren't asking for obsolescence based upon the sale. They were asking for it based upon the appraisal. The assessors all testified that they did not rely on the appraisal. They explained why. That was upheld all the way again to the Louisiana Supreme Court. The claim that Perdido is trying to rerun today.
Let's hold up on Brian. That's more in closing. I
Okay,
think you've answered.
I'm sorry, I thought I was
That's
answering
okay.
his question,
That's okay.
but
I think you've answered the question.
I mean, my web closed, I think I made it.
Okay, any other witnesses? Any other questions?
No,
for the
no
witness?
further witnesses. I'm sorry.
Can we just say a few words at the end? Mr. Eddington's obviously had plenty of time to state his case.
Okay, we'll give y'all
And that
both,
was-
stop. I'm gonna give y'all both 2 minutes for closing.
Yeah.
So if you wanna go?
Yes, sir.
wanna
Thank
go
you.
First, go ahead.
You know, the tax tables are in those rules, and we have no problem with the way the assessors use the tax tables. We know they're supposed to use the tax tables for these years. We're just also saying that there's also another rule in there, and it's in the obsolescence section, that a recent sale properly documented, arm's length, shall be considered as a measure of fair market value. So that's just as much a part of the rule as the tax table computations are a part of the rule, okay? At the end of the day, we believe that the Court of Appeal got this wrong. It's not a controlling decision. Perdido lost in the Court of Appeal, but it was not a majority decision. One judge wrote it, one judge agreed with the judgment, but not the reasoning, and one judge dissented. And when it went to the Supreme Court just didn't review it. So that's not an upholding of the reasoning of this. This client here submitted for 19, 20, and 21 based upon no guidance. D90 did not come out until late 2020, okay? And so it did not have guidance. They were doing their best to provide you with, the assessors and you, with what they could provide, not knowing what exactly to provide. And so when the D90 case comes out, it basically says this commission has full evidentiary hearing authority to take evidence and witness testimony, which you have the authority to do. And if the initial submissions, the court says, if the initial submissions were lacking, or if they needed clarification, D90 allows presentation of evidence before this commission to establish fair market value. And so you are allowed to see and read all of what's in our submissions, including these exhibits like number 14 that we provided. Because especially in this matter, especially here, where this taxpayer was in a convoluted appeal procedural mess, that's what we were dealing with, you know? And that's why the submissions were the way they are. If there was ever a time for this commission to look at all the evidence and seek some clarification and give some grace to a taxpayer, Perdido's the poster child for that. They really are, because these tax tables don't make sense compared to what these assets are producing. It's not a good measure of value. And that is why the assessors and industry got together and changed the rules going forward. And that's for the later years. You're going to see it in the next hearing. It's for the later years. But for these years, I'm going to give you my opinion. This is a grave injustice. It really is, based upon what these wells are worth and what they produced and what they're being charged just in ad valorem tax. I know I'm a little emotional here. I appreciate your listening to me, but that's our position.
I'm amazed. I'm truly amazed. Perdido made the strategic decision, made the litigation decision to stick with what it did in 18 through 2019, 2020, and also 22 that you're going to hear in a couple of months. They lost. Not binding precedent. I'm sorry, that is absurd. Of course it's binding precedent. They're the parties. It's a final judgment. The Supreme Court didn't say, we're not going to hear it. The Supreme Court denied their writ application, raising all of these issues he is re-arguing. There is nothing, I want to repeat, nothing that they are arguing today that they have not argued all the way to the Louisiana Supreme Court, and again, at the risk of being redundant, lost. How many times, how many bites at the apple do they get? Usually when you get to the highest court in the land, that's it. Yes, we have transitioned to the income approach. This is an issue that will go away. But I do want to say that Mr. Palazzolo has pretty significantly misrepresented the law about, he's basically suggesting that this is a trial, that they get to present new evidence. And the D90 decision, again, came out before any of the rulings from the Court of Appeal or the Supreme Court's denial. They made all these arguments. They lost. D90 does not say that you get to have a trial. The law has always been, and again, after D90, the First Circuit specifically held that the burden is on the taxpayer to provide the assessor with data supporting an obsolescence claim, and that the assessor retains the discretion to review that. That was the issue then. That's the issue today. None of that has changed. Now, of course, because of D90, we did change the law. And now it provides, and it is embodied in these regulations, and it's a procedural rule. There's nothing that says it doesn't apply. The rules specifically say that review of the consideration of the correctness of an assessment by an assessor is limited to review of the evidence presented to the assessor. What do they give the assessor? The same thing they did in 18, because they didn't want to rock the boat while they were going up. I'm sorry. There are consequences to that decision. They could have given more. After there was a ruling pointing out that they didn't provide any of the supporting documentation for the appraisal, they could have provided it. After there was a ruling by the tax commission initially saying that this was the sale of a going concern, not a simple asset purchase sale, and that without more information or further explanation, it was not indicative of fair market value, they could have provided more information, further explanation. They didn't. Again, this case has been litigated at the Supreme Court. It's over. I don't know why we're here. I don't know why we spent the last 4.5 hours for a case that should have been oral argument and over in half an hour. Thank you, commissioners.
Okay, thank you. Any questions from the commission? I would entertain a motion that we take this under advisement.
Mr. Chair, I'll make a motion to take this under advisement. That way it'd give us enough time to process everything we've heard and what we have to read through here.
Okay, we have a motion. Is there any discussion on the motion?
Mr. Chairman, can we provide you with a post-hearing memorandum, given all the evidence that was submitted today?
We're not going to take any more documents. We're going to follow our procedure. It's nothing against Perdido. We have a rule that you turn in before the hearings. We don't accept anything after. Okay. We have a motion. Any objection to any discussion to the motion? Any objection? Hearing none, motion is adopted. I thank all the parties who are here today. I thank you for our patience. This is one of our first ones we go through, so we'll get a little better at it. Hopefully, we don't see y'all again soon. We'll probably see Brian, but not y'all. But thank y'all so much,
See you
and
back
we
in a couple
appreciate.
of months, sorry.
Yeah, we appreciate y'all patience, and we appreciate the effort that you put forth. Thank you.
Thank you, commissioners.
At this time, being no other business, do I hear a motion to adjourn?
The chair have a motion to adjourn.
We have a motion to adjourn. Is there any discussion? Any objection? Hearing none, motion is adopted. We are adjourned at 1:25 PM.